Okay, good morning, everybody, and welcome to our 10 a.m. Pacific time webinar on FinCen's new geographic targeting order. To introduce today's webinar, I'm going to turn it over to Craig Page, Executive Director for the California Land Title Association.
Good morning, everybody. Thank you for attending the webinar. I'm the Executive Vice President and Counsel of the California Land Title Association here in California, and we're doing the co-hosting with the American Land Title Association. I'd like to thank you very much for hosting the webinar and doing the lion's share of the work for this presentation. I just want to quickly introduce our speakers, and then I'll turn it over to them so we can get into the meat of the presentation, and they'll walk you through the format that they're going to use and how they'll handle questions, etc. The first speaker that we have is Lawrence Scheinert, who's the Acting Director of FinCen's Office of Special Measures. The Office of Special Measures is responsible for implementing a variety of unique statutory authorities provided to FinCen, including geographic targeting orders, which is designed to collect targeted financial intelligence. The other speaker that we have from CLTA is Jim Nelson. Jim is currently a Senior Vice President and Deputy General Counsel for First American Title Insurance Company and has responsibility for legal and regulatory issues affecting the company's title operations and works in First American's home office in Santa Ana, California. Jim also sits on our CLTA Legislative Committee as well. Our last speaker is Steve Godheim, who's Senior Counsel for the American Land Title Association. He's the Association's Chief Legal Officer and manages ALTA's public policy and regulatory affairs. And with that, I will turn it over to the rest of the panelists.
All right, so thank you, Craig. So on your screen right now, you should see our kind of agenda for today. What we're going to start out doing is Lawrence is going to give everybody a little bit of a background on FinCen, the Bank Secrecy Act, which is FinCen's primary statutory authority, and then some background on geographic targeting orders in general, and then more specifically on this current real estate-focused geographic targeting order that we're talking about today. After that, Jim and myself will kind of go into some of the details on the geographic targeting order and really try to dive into what your compliance obligations will be if you're closing transactions in any of the 5 California counties covered by this order. And then we'll talk a little bit about kind of how this will impact real estate transactions in general before we take questions from the audience. By note for housekeeping, the way we will handle questions on today's webinar is that all questions will need to be submitted through the questions box on the right-hand side of your screen on the bar. So if you have a question, feel free to submit it anytime during the presentation, and we will get to it either in turn during the presentation or at the end of the show. With that, I am going to turn it over to Lawrence to talk a little bit about FinCen.
Great, thank you, Steve. So just by way of introduction, my name is Lawrence Scheinert. I'm the Acting Director for the Office of Special Measures at FinCen, which is the office that does, among other things, is responsible for issuing geographic targeting orders. Just at a higher level as to who FinCen is and how we fit into the broader Department of the Treasury. So we're a bureau within the Department of Treasury, and our mission is to safeguard the financial system from illicit use, to combat money laundering, and promote national security through the collection, analysis, and dissemination of financial intelligence, and to use our authority strategically to achieve that mission. And really what this means is that we wear 2 hats. One, we are the financial intelligence unit for the United States, and so in that respect, we collect, analyze, and disseminate financial intelligence. And then 2, we are the administrator of the Bank Secrecy Act, which is essentially the anti-money laundering regulations applicable to financial institutions. And it is really under both of these hats that the real estate geographic targeting orders are relevant. And just by way of background as to what a geographic targeting order, or a GTO, as we call them, as to what it is and what the authority is, it's an authority that allows FinCen to issue a temporary order under the Bank Secrecy Act that imposes additional record-keeping or reporting requirements on domestic financial institutions or other businesses in a specific geographic area. Now with that, let me talk a little bit about our interest in real estate and why we're issuing these geographic targeting orders, and a little bit about what we've learned from the first issuance back in January. So FinCen remains concerned that all cash purchases, and when we talk about all cash, we're referring to those without bank financing, may be conducted by individuals attempting to hide their assets and identity by purchasing residential properties through opaque shell companies. And the reason we're focused on all cash transactions is because when you have a bank loan involved, the bank is conducting diligence for credit diligence, but also for anti-money laundering purposes. They have an anti-money laundering obligation to report suspicious activity. In most all-cash deals, there's no party directly in that transaction that has an anti-money laundering obligation to report suspicious activity. In addition, when shell companies are used, shell companies have the ability to obfuscate who is actually behind the transaction. And so to better understand this vulnerability, we issued geographic targeting orders in January 2016 covering transactions in Manhattan and Miami. Now I'll talk a little bit about what we've learned so far, because I think that's helpful in understanding why we're doing this and what the value of the information is. And really we're trying to achieve two different objectives. One is to advance law enforcement's ability to identify potentially illicit actors and activities, and then more broadly to help inform FinCen's broader regulatory approach towards anti-money laundering in this sector. And just to give an example as to how the information is doing that, so far over a quarter of the transactions covered by the January 2016 GTOs involve a beneficial owner or purchaser representative that is also the subject of a suspicious activity report. And what that means, in other words, a significant portion of those transactions that we've been focusing on in the January 2016 GTOs have identified independent indicia of possible criminal activity associated with the beneficial owners. And just to give a couple of examples, in one case we identified a beneficial owner engaged in $16 million of suspicious cash withdrawals. Another is a beneficial owner possibly involved in dealing with counterfeit checks. And another, a beneficial owner connected to a network of shell companies that received about $7 million in suspicious wire transfers from businesses in South America. And so these GTOs help link this previously unconnected suspicious activity to the true purchasers of luxury property in the case of the January GTOs in Manhattan and Miami, which essentially corroborates FinCen's concerns that this narrow subset of transactions, which we'll talk about in a minute, but essentially they're all cash luxury purchases of residential property by a legal entity, are susceptible to money laundering. And the data suggests that we are on the right track by focusing on these types of transactions. And so by expanding the GTOs, we will learn even more about the money laundering risks in the national real estate market, helping us determine our future regulatory course. So to build on that useful data thus far, as I'm sure many of you are aware, we extended the geographic targeting orders recently to include all boroughs of New York City, Miami-Dade County and the two counties immediately to the north, Los Angeles County, the counties comprising the San Francisco area, San Diego County, and the county that includes San Antonio, Texas. And we determined that these cities should be covered based on various factors, including the prevalence of shell companies used in all cash transactions, information provided by law enforcement, and the extent to which the area has a luxury market attractive to foreign buyers. Now these July orders become effective on August 28, 2016, and remain in effect for 180 days. Before I dive into exactly what those orders require, I just want to highlight that the issuance of the GTOs in January was really the first phase of a pilot project to learn more about the money laundering vulnerabilities of the real estate sector. And as I noted, the data suggests we're on the right track by focusing on this narrow subset of transactions. But let me be clear, FinCen does not expect to solve the complex problem of money laundering through the real estate via temporary orders. These are simply data gathering tools. And so by expanding the pilot project to cover more cities and more transactions, we will gather more data to help inform our broader long-term approach. So with that, let me talk a little bit about what is specifically required under the orders. The orders require U.S. title insurance companies to report certain information on covered transactions. And we'll talk about what that information is, but first, let's walk through what a covered transaction is. A covered transaction is a transaction in which a legal entity, which is defined as a corporation, limited liability company, partnership, or other similar business entity, when a legal entity purchases residential property within the specified geographic area at the specified monetary threshold, and we have a slide in a little bit that'll break down the monetary threshold for the different area. So a legal entity purchases residential property in that area at the monetary threshold, and such purchase is made without a bank loan or other similar form of external financing. In addition, such purchase is made at least in part using currency or a cashier's check, a certified check, a traveler's check, a personal check, a business check, or a money order. Now, when a U.S. title insurance company is involved in such a covered transaction by issuing title insurance, they are required to report to FinCen on what's called a Form 8300 certain information about that transaction. And that information includes information about the identity of the purchaser, so that would be the business entity making the purchase, and that's the name of the entity, the address, etc. Information about the beneficial owner of the purchaser. So that means information about the individuals who directly or indirectly own more than 25% of the equity interest of that purchaser. Information about the identity of the primary representative of the purchaser, in other words, the person who has the authority to act on behalf of that legal entity. Information about the transaction, such as the date of closing, total purchase price, address, etc. And those are essentially the requirements. This information must be reported to FinCen within 30 days on the FinCen Form 8300. The next slide shows, at a high level, what has changed from the January 2016 orders versus the July orders. And just to walk through them real quick, the July orders cover all title insurance companies, and obviously, as we talked about, they expanded the coverage beyond Manhattan and Miami, and payments made using personal or business checks are also included in the July orders. The next slide shows the specific regions that are covered and the applicable monetary threshold. And then Steve is going to talk a little bit about some particular issues that have arisen, but I'm going to pause here to note that we understand that issues may arise in certain transactions, and one thing that we want to emphasize is that we encourage all of you to call with any specific questions you have when you're facing a transaction. And we have our number on the press release and on the orders on our website. You can call us anytime. But you can also reach out to me directly. My contact information is available through this webinar. And really, we want to get back to you as soon as possible. We understand that transactions may be time sensitive, and we really do our best to provide clarity. And so I'm not going to take any questions on this call. I know Steve and others may, but I want to emphasize that you are more than welcome to reach out to me directly, because we want to get you answers and provide them in writing so that you can rely on them and provide specific clarity. So with that, I'm going to pause and thank everybody for their time this morning.
Okay, thank you, Lawrence, so much for participating with us and for working with us on this webinar and for helping out the industry as much as you can in terms of answering questions. I will emphasize what Lawrence said, which is if you ever, we're going to go over some high-level information about the orders over the rest of this webinar, about who's covered and what types of transactions are covered and how to report. However, we're going to try to keep this to as high level as we can, but if you do come across very specific fact patterns in your actual day-to-day transactions and are really trying to figure out how to get these orders to apply to those transactions, your best course of action is always going to be to call the folks at FinCen and Lawrence and his team, and they will try their best to get an answer to you as quick as possible. So now we're going to talk a little bit more about who is a covered business, because as Lawrence kind of mentioned, right, that the concept here is that if you're one of these covered businesses and you have a transaction that you are going to insure that is a covered transaction, then you need to report it within 30 days of the closing to FinCen on the Form 8300. So the first question for most people on this webinar is going to be, who are the covered business? Who actually has an obligation to report? And the basic answer is that this order covers all United States title insurers, including title insurers that do not currently have operations in any of the counties that were listed in the Geographic Targeting Order. So all title insurers received and are obligated under this order to report transactions if they have any in those counties. But it also includes their direct operations, their subsidiaries, and their agents. The important thing to remember is that because agents are brought into this order, the important thing to remember is that regardless of how the insured elects to do this, whether the insurer will file reports and ask the agent to report information up to the insurer, or whether the insurer is going to rely on the agent or the underwritten title company to provide the reports to FinCen directly, no matter what, FinCen only wants to get one report on a transaction. And so this is why it's very important for you to take a look at all of your underwriting bulletins, especially if you work for multiple underwriters, to understand exactly what the nuances are between each of them in terms of how they want to handle this GTO, so that you know exactly what your obligations are when handling a covered transaction. The other thing to think about is kind of the trigger, and so we hear this question a lot, which is, you know, when in the deal will I know, or what has to happen to know that I have to report? And really the answer is really, again, because this is focused on United States title insurers, the focus is on whether or not you're going to be offering title insurance or actually providing and issuing a policy of title insurance to the purchaser. In transactions where you don't provide a policy of title insurance to the purchaser, you then don't become a covered business. So if you're just handling the closing but not issuing title, that would not make you a covered business. So again, a very frequently asked question. If you're an underwritten title company or an independent agent that is an agent for multiple title insurers that are covered by this geographic targeting order, which insurer has to report the covered transaction? And really, again, this comes down to the question of who's providing the insurance, whose name and whose liability is going to be on the line for the insurance policy, because that's going to be the insurer that's underwriting bulletin has to be followed in this transaction, and it's also the insurer that's going to have the requirement to report this transaction to FinCen. And so it's very important that you kind of utilize that you really pay attention to what those bulletins say and understand exactly what the requirements are there. So now I'm going to turn it over to Jim to talk a little bit about what what constitutes a covered transaction.
Yes, good morning, everybody. A covered transaction, the buyer must be a legal entity defined under the GTO as a corporation, limited liability company, partnership, or other similar business entity, whether formed under the laws of a state or the United States or foreign jurisdiction. It has to be residential property located in one of the covered jurisdictions. And as based on our experience with the previous orders, the definition of residential is the HUD definition. For a purchase price at or above the dollar threshold, with or without a loan or similar form of external financing from a financial institution, and any portion of the purchase price is paid using currency, cashier's check, certified check, traveler's check, personal check, business check, or money order. New to this new order is the personal check and business check. So if you have been operating under the previous orders, personal checks and business checks were not included. In this new order that takes effect August 28th, personal checks and business checks are definitely included. Now, what's not included here is wire transfers. If it's a wire transfer, you don't have to worry about it. But keep in mind that where we often might forget or overlook earnest money. Earnest money is considered a portion of the purchase price. So therefore, even if that earnest money is $500 or $100 or whatever, and it comes in one of these forms, that triggers the reporting of the transaction. All right, next slide, please. Here are some of the frequently asked questions based on our experience that we've had, and there were 4 insurers that were involved in the initial round of orders, Fidelity, Stewart, Old Republic, and First American. And so we have some experience in some of the common questions that keep coming up. Is a trust a legal entity? We asked this question early on in FinCen, and FinCen agreed that no, in most states, trusts are not distinct from the trustee, so they did not consider them reportable transactions if the trust was buying it. However, here in California, I understand that the California Escrow Association has issued materials which say that trusts are covered transactions. So we have to work on that discrepancy between materials that are going out, and that's one question that we're probably going to pose to FinCen. And I think what we want to do is have as bright a line for our escrow personnel as possible so that they don't have to analyze every transaction and they can move forward with the transaction as rapidly as we expect them to. So I think that a bright line here might be if the trustee is an individual, you know, Joe Smith as trustee for the Smith Family Trust, that probably that might be one way to draw the bright line, and that transaction might not be reportable. But if the trustee is a legal entity or it's considered a business trust, maybe those trusts would be reportable. But that's something that we're probably going to have to seek further clarification for here in California from FinCen. What does the term residential property mean? As I mentioned earlier, it's the HUD definition. Real property including individual units of condominiums and cooperatives designed principally for the occupancy of from 1 to 4 families. Another area that is kind of interesting, and the different companies might look at it slightly differently, and it may be another area we need to get clarified from FinCen, is what about, we definitely know that vacant land is not considered residential property, but what about property under development? At what point in the home builder process does that property take on the residential nature? Grading of the lot, the pouring of the slab, the framing. We think that perhaps a bright line that might help our escrow personnel here would be a certificate of occupancy. That if there has been a certificate of occupancy issued, then we can consider it residential property. Prior to that, it's not residential property. And that perhaps is something we need to seek clarification from FinCen as well on, just to make sure that we are reporting properties in development or being built by home builders. Does private or seller financing qualify as a bank loan under the GTO reporting requirements? On a case-by-case basis, yes. Generally, a loan from financial institutions triggers the exemption. And the reason, of course, is I think you've heard Lawrence Scheinert say most banks, most formal financial institutions already have anti-money laundering programs and reporting requirements for suspicious activity. So if it's a bank loan from one of those types of institutions, then you can generally rest assured that it's not going to be a covered transaction. Are the reporting requirements triggered when the purchase price is paid entirely through a wire transfer? No. Short and simple. If all the money, including the earnest money, comes into the transaction via wire, that is not considered a reportable transaction. Next slide, please. Is there a de minimis threshold of currency used in the transaction? No. And we had this clarified by FinCen in the early round. If any portion of the purchase price, and that can be $1, is paid via the covered payment methods, the transaction is reportable. And FinCen was very clear on that. What if ancillary settlement services such as the survey, inspection, or closing attorney's fees is paid using currency? No. Again, the orders cover only the purchase price if the purchase price is paid using the covered payment methods. Next slide, please. What must be reported? Within 30 days following the closing, the covered insurer or its agent must file a Form 8300 with the following additional information. identity of the individual primarily responsible for representing the legal entity, and this could be their attorney, or in the case of an LLC or a corporation, the president or whoever is handling the transaction. A description of the identification, driver's license, passport, or other similar identifying document obtained from the individual primarily responsible for representing the purchaser, with a copy retained in the file. Identity of the purchaser and any beneficial owners of the purchasers. A description of the type of identification, driver's license, passport, or other similar identifying document obtained from the beneficial owner, with a copy retained in the file. Next slide, please. The date of the closing of the covered transaction must be reported. The total amount transferred in the form of a monetary instrument, the total purchase price of the covered transaction, and the address of the real property involved in the covered transaction. Also, and this is important, this was a common reporting error that several of us made in filing incomplete reports during the original GTOs. They require this term in all caps as a unique identifier in the comment section of the Form 8300. REGTO, that must be listed in the comment section of the Form 8300. Next slide, please. How does the GTO define a beneficial owner? An individual who directly or indirectly owns 25% or more of the equity interest in the legal entity. And one of the things that's important to know, if the beneficial owner, if the 25% owner is another legal entity, FinCen is expecting us to drill down to get to the individual. They want the names of the and the identifying information of the individuals behind a legal entity. What if the purchasing entity is owned by a series of legal entities? Again, we must report the ultimate beneficial owner, the individual, at the end of the chain, individual or individuals at the end of the chain. Can the insurer rely on information reported by the parties or collected by a third party, such as an attorney? The answer here is yes. And this is a very important point, that the insurers that were affected by the original orders sought clearance and a clarification and received clarification from FinCen on this. A covered business may reasonably rely on information provided to it by third parties, including other parties involved in the transaction. So we aren't the truth police. If the parties in the transaction tell us something, we are entitled to rely on it and move forward in the transaction. A similar related question, must a covered business verify information about the beneficial owner of a purchaser? A covered business must obtain and retain a copy of the beneficial owners or all members of an LLC, driver's license, passport, or other similar identifying documentation. But we do not need to verify their status as a beneficial owner for purposes of the GTO. Now, for purposes of our, who has authority to enter into the transaction, our normal underwriting provisions and conditions is one thing. But for the purposes of the GTO, we do not have to verify the status of the people that are related to us as beneficial owners. Next slide, please. Who is the individual primarily responsible for representing the purchaser? The individual primarily responsible for representing the purchaser means the individual authorized by the entity to enter into legally binding contracts on behalf of the entity. And again, that can be their attorney. Is this information subject to an attorney-client privilege? No. Information necessary for completing a Form 8300, suspicious activity report, or other Bank Secrecy Act reporting requirements cannot be withheld from the government due to attorney-client privilege. And there is the case citation for that there on the screen. This was also clarified definitively by FinCen. There is no attorney-client privilege for this information. It cannot be denied. Next slide, please. Compliance. A covered business is expected to have reasonably designed procedures to ensure compliance with the terms of the GTOs. Now here is where the initial 4 companies had slight variances in their processes and procedures. With the new round of the GTO through February and the anticipated probably permanent reporting requirements going to be placed on the industry in the future, working through ALTA, we hope to have more unified and streamlined process and procedures so that agents don't have to figure out which company I'm working with and what's the nuances in those particular procedures. But reasonable due diligence to determine whether it or its subsidiaries or agents is involved in a covered transaction, to collect and report the required information, and we may, again, reasonably rely on information provided to it by third parties. So, in general, a covered business should at least have a couple of provisions in their process, and that includes communication of the GTOs, bulletins, underwriting bulletins by insurers, education and training and tools for the staff, monitoring, periodically test and check that your escrow officers, your settlement service agents are doing what they are supposed to be doing in these reporting requirements. Auditing, I think we are, as covered businesses, have a responsibility to do auditing to ensure that our escrow officers and our settlement service providers are doing the correct things they need to be doing under these orders. Feedback with FinCen, I have to tell you that FinCen has been a very good federal agency, regulator to deal with. They have been responsive. They pick up the phones when you call them. They have been very helpful in providing guidance on any question that you may have. And you heard Lawrence say, call me if you have a question. And absolutely, we can certainly do that. We have done that many times. So check in with FinCen on occasion just to make sure that how are things going? Are you seeing any kind of common mistakes in the forms that we are filing? And they will be happy to tell you that. And then don't forget the records retention requirement in the GTOs. There is a special records retention requirement. We all must retain those records 5 years from the last day the GTO is effective, which is in this GTO currently February 23rd of 2017. Our reports can be shared with law enforcement, but they are otherwise kept private and are not FOIA accessible. Steve, I think you're next.
All right, thank you, Jim. So what we're going to move on to in our next grouping of slides before is kind of some of the resources that we've developed here at ALTA and are making available to all of you as members and participants in the industry to help make this an easier process for your compliance. Because as Jim kind of alluded to, compliance can be a little bit tricky. There's a lot of information you're going to need to collect from a purchaser or their representative to be able to complete the Form 8300. You're going to want to rely on that information that purchaser gives you, and so it's all about making sure that you have the tools that you need to get that information in a timely manner. Because one of the questions that we get the most frequently here at ALTA that hadn't quite come up yet on our questions chain, and I'll remind folks that if you do have a question, please submit it through the question box, and I know we've gotten about 6 or 7 that have come in already and that we'll answer at the end of the presentation. But one of the most frequent questions that we get is, what if the purchaser or their real estate agent just won't provide it? They insist on not telling you anything about who the beneficial owners are of this company. What is a title agent supposed to do? And then the tough part of the answer to that question is that the expectation is that if you are going to insure a transaction that would meet the requirements that Jim talked about, that you are able to fill out a complete 8300 completely with all the information. If you're not going to be able to do that, the expectation is then that you're not going to insure that transaction. One of the things that we did not talk about in that last grouping of slides is to remind folks that, as Jim kind of talked about kind of what it means to kind of have a good compliance program in place, it's important to do that because a failure to comply with the order, especially a willful or knowing failure to comply with the order, can open up you personally and your company to criminal and civil penalties, including jail time. And so it's important to make sure that you do take this very seriously. So again, at ALTA, we've produced a number of resources to help make this a little bit easier for you over the next 6 months. The first one of our resources is the one on the screen right now. It's our covered transaction determination form. The purpose of this form, or kind of the idea behind this form, is this is a simple 5 or 6 question, thing that you can use to understand, yes, this is a covered transaction, and so I have to report it to FinCen, or no, it's not a covered transaction. It's a very helpful type of document, especially useful for training purposes with your staff, but also a good thing for your staff to make sure your staff maybe fills out, keeps in your files, especially if you have transactions that you are not going to report that would seemingly meet the requirements of the covered transaction because they're, say, in San Francisco and they're over $2 million cash. But you're not going to report it because it all came in via wire transfer, for example. So think about how you might use this in your operation. Our second form is our GTO information collection form, and the idea here is this is the type of document that it's a 4-page document. You can give this to a real estate agent or the purchaser or their attorney and use this to collect all the information that you would need to report on the 8300. And so this would be, again, to that point that Jim made earlier about relying on the information provided to you, a great way to gather that information and then use it to be able to rely on. It's also important to think about when in the transaction you might use these documents because, again, the earlier you use this information, the earlier you make the parties aware that they might have to report this information, the easier it's going to be to collect it, the easier it's going to be to get it and be able to report in a timely manner. Other resources that we have available to you are on our website at alta.org/FinCen. The 2 resources I really do want to point out to you as very helpful. One is our updated ALTA fact sheet. We've updated it for this GTO. It's got some more frequently asked questions and information about the GTO and about FinCen and kind of how this whole process works. FinCen is currently in the process of updating its FAQs with frequently asked questions, and so they'll have a new version of that available on their website. It'll also be on our website as well when that is available as well. And then I think also a very good read for background is it's from, I believe, our February title news, The Hunt for Dark Money. You can read a copy of that article on our website at alta.org/FinCen. So before we start taking questions, I think it's just a good idea just to rehash kind of how we've seen this impact the real estate market in the 2 jurisdictions that have already been going through these data collections, but also how we think this will work going forward. And really what we've seen is that, you know, the first question a lot of times is this going to prevent closings? Is this going to delay my closings? And hopefully the answer is no, it shouldn't prevent your closings because, again, this is about data collection after the fact. But obviously, the earlier you bring this up to your customers, the easier it'll be to gather that information and hopefully the lowest chance of delaying your closing because you'll have gathered as much information as you can early on so that you'll be able to meet the reporting requirements. You know, I think a lot of people have that question of, well, are customers going to be willing to provide this information? What if they won't provide it? And I think one of the things to remember is that this is very much for a lot of the customers that you have going to be the exact same type of information they provide to their bank when they're opening up a bank account. So they're used to providing this type of information. It's just providing it to you now as opposed to just the bank. And hopefully that will make it easier, and hopefully, because I don't know if Jim has other thoughts on it, but you know, we have not heard reports at ALTA of people really not being willing to provide this information to title companies when it's requested for the Miami and Manhattan geographic targeting orders. So with that, I know we now have a number of questions that have popped up already. I am going to take a second quickly to just open up our question box, and then we will start discussing some of them. I will just remind you that if you have a question, please submit it through the question box on the control panel on the right-hand side of your screen. We're going to get to as many questions as we can in the next 19 minutes that we have left in today's webinar. There may be some questions that we are not able to answer in a manner that is most beneficial to all of you. Those are likely to be the types of questions that are about very specific fact patterns. I'm going to encourage anybody that has very specific fact patterns, like I know there's at least one in here about convertible debt, that they really should hopefully pose those questions to FinCen. We'll forward any questions on to FinCen as well. But again, to remind you that if you have specific questions about specific transactions, your best course of action a lot of times is to reach out to FinCen directly, because they'll give you the most useful information about understanding your compliance obligation. So our first question comes from Linda, and her question is, what if the earnest money comes via a check but is later refunded to the buyer and replaced with a wire transfer? Is that initial deposit, which may have been returned, reportable? So I'll give you my thoughts on this, and then Jim, feel free to contradict me in any way that you'd like. But the reporting requirement and kind of the funds requirement is really about how the money initially, for the first time, gets into the transaction. And so it's not about how the money ultimately gets to the settlement agent or the escrow agent, and it's not about how that money eventually comes out of the closing or the settlement, but really how it initially gets from the buyer's hands in the first, or account in the first instance, into this transaction in some form. And so if it's coming in via check and going to a real estate agent, and then that real estate agent wires it into the settlement agent or the escrow agent, that's going to be reportable. To me, I would say if it's paid in by check and then that check is refunded to the buyer, and then the buyer resubmits it via resends that money via wire transfer, I would take the cautious route and report that transaction as well. I think a lot of times you're going to when you find that fact pattern, the only reason that you're going to refund that check to the buyer is to try to avoid the reporting requirements, and so that's going to be something that's very interesting to FinCen, and something that they do pay attention to is trying to understand the behavior of companies as they try to avoid this reporting requirement.
Yeah, this is Jim. As a practical matter, what we have tried to tell our folks is the general guiding principle here is, when in doubt, report. Our companies will never be in trouble for over-reporting. We will be in trouble for under-reporting. And you have to ask yourself, is the reason the person withdrawing that and then resubmitting it by wire, is the reason they're doing that is to avoid the purposes of the GTO? That raises a red flag. That is exactly the type of person or individual that the FinCen would be interested in. So that transaction is reportable. When in doubt, report.
I think that's a great advice, and just a corollary to that. Even if you don't think it is reportable, but you do have just a somewhat suspicion on this transaction or a weird feeling on it, beyond this GTO, you always have the option of filing a voluntary suspicious activity report if you ever come across a transaction that you believe doesn't seem quite right, and want to make the government aware of. Our next question comes from Andrea, and she asks about the concept of beneficial owners and trying to identify them, because typically in a corporate scenario, they are probably not going to be present at the closing. And so how do you gather this information? And I think the important thing to think about here for this type of question is, again, you do have the ability to rely on what the person, whoever you do have contact with in this transaction, whatever they tell you about who the beneficial owners are, as long as you're able to get their identification, a copy of their driver's license or passport. And so the thinking about this, the more you get this information ahead of time, or at least start the conversation before you even get to closing, and making sure that you know that this is a piece of information you need to have in your hands before you're willing to close the transaction, the easier it'll be to make sure you don't run into that time clock and don't run into having to try to track stuff down after the fact. So our next question comes from Alan, and he asks, with dollars being fungible, how do you handle the scenario where maybe you wire transfer in an amount that covers the entire purchase price, but then the rest of the money for all the closing costs comes via check, or actually in cash or things like that? How do you handle those types of scenarios? And I'll open this to Jim if you have any other thoughts, but I would say Jim's earlier statement is probably the right one, which is it's always the safer scenario to just report it. FinCen does purchase transaction data, post-closing transaction data from a data provider, and so they do look at that to try to understand how many transactions they think should have been reported and how many actually were reported, and you want to be in a position of being able to defend why you didn't report a transaction if they think you should have. And so think about, what's the safer course of action? It's always going to be to report it if you think it meets the criteria in some form.
Right. The order specifically talks about the purchase price. So we have literally taken the order on its face, and we have also talked with FinCen about some of these ancillary services and settlement charges. FinCen has repeatedly gone back and said the purchase price, the purchase price. The ancillary charges and other closing costs that may be paid outside of closing, or services that may be paid for by the purchaser, other than the purchase price, will not make that transaction reportable. However, we believe that you should use a rule of common sense. If there's a lot of money going through, a lot of cash going through the transaction, you have to keep an eye on it, use common sense. But in general, if it's money for the purchase price, it's going to trigger the reporting. If it's money for anything else, it won't trigger the reporting. Again, a bright line for our folks.
All right. So, Jim, I'll let you take a stab at this next question. It comes from Tina, and she asks, what if the purchaser is an LLC that has 10 members, each with an equal 10% ownership interest in the LLC? Is that transaction reportable? And how would you and who would you report?
Well, that's a very interesting question. The legal entity, of course, means a corporation, a limited liability company, partnership, or other business entity. You have to report beneficial owners who own directly or indirectly 25% or more of the equity interest of the purchaser. So in that particular instance, and others may disagree with me on that, but I'm not sure that that's a reportable transaction at that point.
So I agree with that to a point, Jim, which is in that instance you may not have anybody that you're reporting as the beneficial owner because no one has that 25% threshold. The other thing to remember is that since this is an LLC transaction, the order also requires that in every instance all members of the purchasing LLC be reported. And so in this instance, it would be all 10 of these individuals would be reported. If you changed that scenario and just had it as a corporate entity in which there were 10 shareholders, each with an even number of shares, in that instance you may not have to report any beneficial owners, although you would still report the transaction and the company and the person who's primarily representing them.
Right. Right.
So our next question comes from Shannon, and it's really I think a good question for California practice. So as an escrow company, in a scenario where you have a split title company and a separate independent escrow company, what is the escrow company supposed to do to advise the title company that a transaction is reportable, so that the title company can complete the Form 8300, or should the escrow company complete the Form 8300?
That's an
go ahead, Jim.
Well, that's a very interesting question. You know, the order talks about the companies and their subsidiaries and agents. The question is an independent settlement agent, an agent of the company. I think that the independent escrow companies are responsible for filing the reporting documents and things as well, because they are the ones that actually take the money in, handle the transaction, and the title company may not know until the transaction's over with that it was completed. So I think the independent escrow companies actually do have a duty to be a part of this process as well and do the reporting. Others may disagree on that.
Right, I think that's the right point, Jim. I mean, you know, part of those escrow instructions that escrow company is going to need to be complying with are that they'll have to be able to ensure that a title policy is going to be able to be issued. And so if they're not making sure that they're getting that information that's required for the title company to be able to complete this obligation, then they may not be able to meet all of their escrow instructions. And so it's important, I think, for underwritten title companies and for escrow companies to really be talking very closely as you find transactions that seem to meet the four corners of this order to understand what's going to need to be gathered by who and kind of at that timing. Our next question, so we have a question that came in from Gerald about the case citation about attorney-client privilege. I will just advise folks that you can obtain a copy of this presentation along with all of the materials that we showed on the screen as resources through the handouts function on the side screen. You'll also all receive copies of the recording of this presentation later next week as well, so you'll be able to get that information as well. Our next question comes from Steve, and he asks, what if a qualified or covered transaction falls out at the very last second? Do you need to report that, or would you submit a suspicious activity report? I would say the kind of simple rule of answer here is the triggering event for reporting a transaction is that a policy of title insurance is issued by one of the covered insurers. So if no title insurance is issued because the transaction fell through, you don't necessarily have a reportable transaction. However, if part of the reason is that it fell through is because of something otherwise suspicious that you think might be related to criminal activity or money laundering, you may want to file a suspicious activity report on a voluntary basis and provide that information to FinCen. All right. Our next question comes from Ron, and Ron asks, how does this GTO relate to 1031 transactions? I know I have a couple of thoughts on that. Jim, do you have any?
No.
So I would say, Ron, the simple piece of this answer is this GTO doesn't treat 1031 transactions any differently than any other real estate transaction. So if it's for the purchase of residential real estate, even and it meets all the rest of these thresholds, I would say it probably is covered. One of the tricky things that I think you'd find out that you would find with people who do a lot of 1031 transactions is even though 1031s are limited to business or investment properties only and not to your residential familial properties, that doesn't mean that it can't involve a residential property, because you could, of course, have a business that's exchanging property and buying a property that they intended to operate as a rental business. And so I would say, there's nothing explicit in here that would seem to take and treat 1031s any differently. 1031s may create different compliance hurdles that you have to overcome, especially given the way funds are going to be held by the qualified intermediary. And so I think it's best to really be very thoughtful in those transactions. And I would say if you ever come across a transaction that you think is a 1031 that you think would be covered, I would call FinCen right away and start asking them how to handle that. So our next question comes from, let's see, we've got a handful more questions. I don't know if we're going to get to every question before the top of our hour, but our next question comes from Casimir, and he asks, in the example of multiple persons owning less than 25%, wouldn't you still need a reporting of the individual primary responsible for representing the legal entity, even if no person owns more than 25%?
The answer to that is absolutely yes. There are two segments of the form. The part one is the person representing the entity, and part two is the owners or the beneficial owners or the purchasers. And so let me do clean up my bungle on that original question. If the legal entity is an LLC and that's the purchaser, then we are responsible for naming all of the members of that LLC. So in the instance of this question, yes, we have to report the individual responsible for the transaction and the members of the LLC. And let me say that in the form, one of the common errors that we have made that FinCen has pointed out in all the reporting by all of the companies, if the person that is responsible is also the purchaser, in some of the forms they have seen, people only complete part one, the person responsible, and then assume that just because they've already listed them in part one, they don't have to list them again in part two. And FinCen has said no, they want to know part one and part two. So even if the information is duplicative, they want to see it again.
Okay, so good answer. So our next question comes from Moira, and Moira asks, how many layers back are we supposed to go if the purchaser is, and if the beneficial owner of the instant purchasing legal entity is another legal entity?
FinCen has made it pretty clear they want to know the individuals. They're looking for individuals and driver's license and passports. So you have to dig down as far as you can to get to the individual behind the transaction or behind the entities, individual or individuals. Is that a good answer, Steve?
I think that's a great answer. So we've got maybe 2 more minutes left in our program. We've got 5 or 6 questions, so we're going to try to see if we can knock them all out really, really quickly. Linda asks, if a transaction is over the number threshold and in one of the counties, but it involves multiple buyers, one of which is a natural human individual and the other is a legal entity, is that a reportable transaction? And I'll just say I think that is not the standard type of transaction contemplated by the GTO, in which you have kind of the multiple buyer scenario, but the way this is written is written to contemplate the idea that if any of the buyers are legal entities, then it's going to be potentially reportable. And so I will tell you, if you've come across this scenario, the first thing I would do is pick up the phone, call FinCen.
Yeah, again, I think the general guideline of when in doubt, report is the better thing to do.
So Sharon asks, regarding trusts, the California Escrow Association indicated that any business entity, including a business trust, would be covered by this GTO. And then ask, can you elaborate on that or talk if that's a true statement? All I will say is that your standard trust, especially an estate planning trust where the trustee is a natural person and the beneficiaries are all natural people, that's the scenario that FinCen has talked about with their question and the answer that they've provided us about it really being dependent on state law, and so I'll urge all of you to, not a California legal expert, to be able to say, you know, to the degree that you have business trusts in the state that are treated and seemingly like a corporate entity or a legal, a non-natural person, those are probably going to be covered here. But anytime you have trusts that are kind of your more traditional trusts that are treated as a natural person because they operate through the personage of the trustee, that's what FinCen's question and answer really gets to. So if you have that in scenario, again, it's going to be the refrain from us a lot today. Pick up the phone, call FinCen, you know, double check. You know, it's always better to double check and get it right than to not make the call. Our next question comes from Norma. Norma asks, what if you have a scenario in which it's a new construction where the developer is charging a developer fee, and when you add the developer fee to the rest of the purchase price, that's what gets you over the dollar threshold? Is that transaction reportable?
Yes, again, if it is part of the purchase price, if it is considered part of the purchase price, then that can trigger the transaction. Yes, as a reportable transaction. Any element of the purchase price.
Our next question comes from Marianne. Marianne asks, do all partners in a partnership need to provide identification and information similar to all members of an LLC? I'll just say that the all members of the LLC concept is something very specific to LLCs. For all other types of corporate entities or legal entities, including partnerships, LLPs, limited partnerships and the like, all that needs to be recorded is the information about who the purchaser is, that entity's information, the person primarily responsible for representing that purchasing entity, and then any people who would be qualified as beneficial owners, i.e. 25% equity ownership. I think we may have gotten to all of our questions, it looks like. So then what I will say is, first off, let me thank all of you for joining us today. Let me personally extend a very heartfelt thanks to Craig Page and the California Land Title Association for co-hosting today's webinar, to Lawrence Scheinert from the Treasury Department's Financial Crimes Enforcement Network for participating on today's webinar, and of course a very hearty thanks to Jim Nelson with First American Title for being a presenter as well. As I said, you will receive a copy of you can get copies of today's presentation along with all of our handouts available on the handouts tab on the control panel on your right-hand side. A copy and recording of today's webinar will be made available to you either on our website at www.alta.org/FinCen, and one will also be emailed to anybody that was an attendee of today's webinar. With that, I want to thank you all for joining us today, and have a great rest of your weekend. Thank you.